Interested as I am. We have some fantastic gentlemen here with us today from SERB, State Employment Relations Board, Dan Sable and Robert Feckety, who are going to be joining us and speaking about recent SERB decisions, statewide benefits and wages data, and the Youngstown State University strike hearing. So we will introduce Robert to you at this time. Judge Feckety is SERB's staff attorney and administrative law judge. He joined SERB from the Office of the Ohio Attorney General, where he was a senior assistant attorney general in the employment law section, where he appeared before state and federal courts and administrative agencies and represented the state of Ohio in an array of employment, civil service, and traditional labor matters, including arbitrations, unfair labor practice charges, and representation matters. Prior to returning to Ohio, which is his home state, go Buckeyes, he practiced law in the state New York City metropolitan area at a large firm representing private companies and public entities. He also has previously served as the chapter president and current board member of Colera, the Central Ohio Labor and Employment Relations Association, our group. And he was appointed in 2010 to the Labor and Employment Law section for the Ohio State Bar Association. He received his bachelor's in psychology. And Robert, I'm going to have to ask you to pronounce this. Is it Chaminade? Chaminade?
You got Chaminade. You got it the first time.
Chaminade. Okay. Chaminade University and his Juris Doctor from Hofstra University School of Law. He also has interned with the EEOC in Washington, D.C. while he was still in law school. He's also a veteran of the United States Navy, where he served in naval intelligence. Mr. Sable is SERB's Labor Relations Administrator, where he oversees the investigation and representation sections. Prior to joining SERB, he represented public and private employers in a wide range of labor and employment practice areas with a focus on public sector labor law. And it included representing public employers in things like collective bargaining negotiations, grievance hearings, arbitrations, and fact findings, as well as advising employers, boards, commissions, administrators, and human resource directors on compliance with regulations and state and federal and local laws. He is also a member of the Labor and Employment Law section of the Ohio State Bar Association and received his bachelor's in business with concentrations in management and marketing from Wittenberg University and his Juris Doctor from the Ohio State University Moritz College of Law. So with that, I will turn it over to Dan and Robert here in 1 second. I will say we will be asking you, if you are requesting CLE credits, for you to enter your name and attorney registration number in the chat log when requested. So please make sure you continue to pay attention to it. We will ask for it at least 2 or 3 times. In order to receive those CLE credits in their entirety, you do need to enter your name and attorney registration number when requested. So please do so for our tracking purposes. If anyone does want SHRM credits as well, we are not pre-approved for them like we are for CLEs, but if you would like a certificate to present to SHRM for your own application of credits, let me know. And I also be adding your name and SHRM next to your name in the chat log when we request the attorney registration information. We will also be putting a copy of the presentation as an attachment in the chat log here shortly. But with that, I will turn it over to Dan and Robert. Thank you, gentlemen.
Awesome. Thank you, Chris. We really appreciate it. And we'll just say we are having some construction in our offices, so there shouldn't be any issues. But if you hear the occasional background noise, that's what it is. And please bear with us, but it shouldn't be too much of an issue. Yeah, so we're happy to be here today. Thanks for having us. Thanks for everyone who joined virtually. We're going to start by talking about some of the resources available from SERB for practitioners and other stakeholders as well. And some of these can be great tips, whichever side of the aisle you might be on. Great, they can be really helpful as you're beginning negotiations, fact findings, conciliations, or just curious how either the client or the pay stacks up. So we're going to go through some of those first. First, the SERB CBA database. This is one of the most exciting new things we've had in the last year, thanks to all the great work from our R&T staff. So previously we had a database on the website that included all the active contracts. But as of late last year, we were able to publish a database that contains all collective bargaining agreements with an effective date after January 1st, 2000. This can be really helpful for various reasons. when I was practicing, it was always kind of hard to, if you were going to fact finding or conciliation and had to argue about what trade-offs may have happened in the past or how the language of the CBA had changed over the years. It was always stressful trying to piece together the past agreements and having to make records requests for those, or just hoping that the client might have some of those from past years. Now that we have this database, it's right there for all the practitioners, stakeholders, anyone who just might be curious as to how the contract language has changed. It's very easy to use. If you just go to our website, click on the Documents tab at the top, then you'll have a chance to click on the CBA link, and then this has the full database, and you can sort it by active contracts if you just want, what's pertinent now, or you can search by past or everything as well. And currently there's 3,522 active or current CBAs, and I want to say somewhere north of 20,000 on there from past as well. Again, whatever you might want to use it for, it's so great to have everything in one place, and we're very proud of that. And thanks again to our R&T staff for doing that. So moving on to the wage settlement report. Some of you may have seen this. We publish this every year, and it covers all CBAs with an effective date in 2023. And currently there were 908 CBAs filed in 2023. And with all these reports, the fact finders report and the wage and health insurance report, it's important to keep in mind, some of the caveats, with one being, with all the reports, they're based on each individual employer, not weighted for the number of folks that might be in a unit. So for example, a 10-person unit getting a 4% raise is calculated the same as a 1,000-person unit, because it's based on individual agreement. So again, just something to keep in mind. And then some of the tables do have other caveats and things like that. But again, just important to keep in mind when you're doing it. So what's actually in the wage settlement report? We have the link there at the bottom should you want to access it. It's really helpful, again, if you're going into negotiations or anything else, or just trying to track the trend over the years. The data is broken down into various groups, including statewide, region by region, jurisdiction, and unit type, for example, police and fire, other things like that. We've included a couple of the pertinent ones, but there are other charts in there as well, and we'll touch on these too, and what the data says a little bit. But we have the average wage increase percentage by calendar year, as you can see here. We also have the wage percentage by calendar year over a 10-year period, so you can again track the trends, statewide, region, whatever you want to do. There's also a chart regarding the average one-time lump sum payment by contract year. And as some of those folks out there on this call that practice in this, as you can imagine, the lump sum numbers go generally, whether or not they're in the contract, go down by which year of the contract it is. For example, the ones filed 123 included lump sum payments in 2023, the first year of the contract, and then 24, 35, and then 2025, 27. So it's interesting to note, as I'm sure a fair amount of you have seen, that the lump sum payments tend to be more at the beginning of the agreement. And again, so if you look at this chart here, you can see that the folks in 2023 that reached collective bargaining agreements, similar to kind of the lump sum situation where the first year is generally higher. You can see the statewide was almost at 4% in the first year, then closer to 3% in 2024, and then a little below 3% in 2025. And you can see the numbers there, and all this is available in the chart as well. And then here is the 10-year tracking cycle you can see. So obviously, coming out of the recession in the early 2010s and everything else, you can see the gradual increase. And then we get to 2023, and it's, as you'd imagine, given inflation and everything else, is higher than in past years. And then we also have our fact-finding and conciliation report, which Chris Young, one of our mediators, puts together every year, or excuse me, every quarter. And again, something to note here is, you know, I know attorneys aren't great at math, but for the attorneys out there, even I know that, you know, if there's a low number in a particular quarter, then one decision that falls, you know, far below the average or far above the average can greatly change the data. So that's something to keep in mind. But it's just an interesting thing to follow that he does publish that Chris does publish every quarter. And you can see here, while there are some outlier years, the general trend is moving upward as well, as you can imagine. And then this isn't in the materials you were sent because it was just published yesterday, but the first quarter of the 2024 year was just published. And again, generally tracks with the rising trends, but again, keep in mind that there's specific reason, you know, might be specific reasons in some of these cases why or why not, you know, the raises were higher or lower. And then with that, we're going to move on to the health insurance report. This is, again, something that our R&T section puts together every year, and it's an outstanding resource for everyone out there that is either practicing or even just wants to see how the trends have changed in public health insurance in Ohio. It's released August 1st of every year. This most recent report was released August 1st, 2023. And it surveys the health insurance benefits in place as of January 1 at each employer. In this particular year, 1,346 public employers were surveyed, had over a 93% response rate. Again, the R&T team is great about following up and making sure they get the data, so this is as accurate as possible, and this is widely used throughout the state. And while you'll have to pull it up for yourself to dig into everything that it offers, as there's, you know, I believe 20 plus tables you can look at in graphs and a bevy of information that is definitely worth looking through. Some highlights that it does include the type of plans offered, the percent change in cost, and the average monthly premiums, both in dollar amounts and percentage amount, broken down by the employer and the employee's share. And it also includes deductible information, plan types, co-pays, really everything you could want. It's a comprehensive health insurance report for the public sector employers in Ohio. And so again, just a couple examples. Here you can see the premium percentages and the increase in the medical care costs compared to inflation, and then the medical care increases as well. So you can see that the premiums have increased more than the cost of medical care, but seem to be in line with inflation to some extent. So again, just one of the tables that we like to highlight or to show stakeholders what is in the report. Another example here is the premium broken down by employer and employee share monthly. It can be important when, you know, again, you're negotiating and you're trying to factor this in as well as the wage increase. Because in some situations, the common thing you'd hear is, well, the increase in health insurance eats up the wage increase. So again, here's actual data to either support or support or disprove a position, however you may want to do that in your practice. And then finally, again, the same chart, but broken down by different jurisdictions and employers, and whether or not it's a county, city, township, school district, et cetera. Everything you might need is there. And should you have any other questions about that, you can reach out to our R&T staff. The links are in the presentation as well, and they're happy to get you any information you might need and do an excellent job. And with that, I'll pass it over to Robert.
Thank you. Okay. So the first case we're going to discuss here is the Youngstown City School District Board of Education and Youngstown Education Association strike that happened in 2023. A little background, in 2023, there were a total of 3 strike notices filed by public unions It was Morgan Local School District, Hamilton County Board of Commissioners, and Youngstown. Of those three, only two actually did result in a strike. And of the two that actually did result in a strike, the employer only filed for an unauthorized strike determination in one of those cases, and that's the Youngstown case. So when an employer files for an unauthorized strike determination, it goes through a revised code 4117.23 process. So once the unauthorized strike determination request is made, SERB is required to determine whether the strike is an unauthorized strike pursuant to revised code 4117.01I. In a request for a determination, the employer has the burden of proving by clear and convincing evidence that the strike is unauthorized. Once the filing is made by the employer, the SERB board has to render its determination within 72 hours of the filing of the request. So in this particular case, the request was made on August 22nd, 2023 at 4:58 p.m. So SERB had until 4:58 p.m. on August 25th to render its determination. Typically, the way SERB has handled this is it's done through sort of an expedited emergency sort of hearing process. So the parties have an opportunity to, they'll put in briefs, sworn affidavits. They might have an opportunity to have some limited witness testimony, of course, exhibits, and it'll be heard before the full board. And that's not required by the code that an actual hearing occur, but that is the way that the board has handled that for most recently. So by way of background in this Youngstown case, March 23rd, 2023, the union filed a notice to negotiate with the school board. Parties met thereafter, and at the first negotiation session, the union declared impasse. Now, according to the parties' collective bargaining agreement, when impasse is declared by one of the parties, they engage in a mediation with one of the mediators from the Federal Mediation and Conciliation Service. So on June 30th, 2023, the collective bargaining agreement expired. And on August 2nd, the union requested fact-finding from SERB. 2 days later, on August 4th, the union withdrew its request for a fact-finding panel. Then 4 days later, on August 8th, the union filed a notice of intent to strike or strike and picket with SERB, indicating that it intended to strike commencing on August 23rd, 2023 at 12:01 a.m. So after the notice of strike was filed, 2 days later, on August 10th, the school board filed a request for a fact-finding panel. The very next day, SERB sent out a fact-finding panel list to the parties. Then on August 11th, the day after the panel went out, on August 14th, 3 days after the panel went out, the union filed a request with SERB asking that SERB rescind its fact-finding panel. It claimed that it had a mutually agreed upon dispute settlement procedure, MAD, in its collective bargaining agreement that did not provide for fact-finding. 3 days from that, on August 17th, the school board asked that SERB deny the union's request to rescind the fact-finding panel. It claimed that the parties' MAD did not contain or reflect any agreement between the parties to forego fact-finding. Further, the school board stated that if SERB believed that there was a question about how the MAD operated, that it should set up a separate hearing apart from the 4117.23 procedure in order to hear that issue. On August 18th, the union filed a response claiming that the MAD was valid and that any determination of its validity could be done during the 4117.23 procedure. So thereafter, on August 23rd, the strike commenced. The school board filed a request for unauthorized strike determination under, again, 4117.23. In its request, the school board asked SERB to grant a stay declaring that the strike was unauthorized until a hearing could be conducted to determine whether the parties had a valid MAD. Conversely, the union argued that they did have a MAD and that SERB should hear it through the .23 procedures. So the parties were given an opportunity to, and in fact did, file briefs setting forth their position, providing sworn affidavits, providing any other documentary evidence that they thought was pertinent, and a hearing was set up before the full board at which the parties' representatives attended and represented their respective sides. At that hearing, the employer cited to a portion of 4117.01I, the definition of unauthorized strikes, that says that during the pendency of the settlement procedure set forth in section 4117.14 of the revised code, that during that pendency of that, a strike would be unauthorized. Of course, 4117.14 is the provision of the code that in part deals with fact-finding. According to the employer, the fact-finding process was initiated when the union made its request for a fact-finding panel, which of course it subsequently withdrew, when the employer made its request for a fact-finding panel, and when SERB responded to the employer's request by issuing a panel. The employer further argued that the MAD was valid, that whether the MAD was valid should be done through a separate hearing and not the .23 process. So the first thing that SERB looked at in making its determination in this case was whether it could determine the validity of the MAD during the .23 process. SERB determined that it could in fact do that, and in fact there was evidence of past cases where SERB had in fact done that, and even one of the cases that the employer had provided to the board in support of its various positions was a case where in fact SERB had made a validity determination during the .23 process. SERB further noted that it had given the parties in this case the opportunity to provide evidence, sworn affidavits, legal briefs, in addition to presenting their case directly to the SERB board, and that they had every opportunity to make those arguments. Having determined that it could make a validity determination during the .23 process. Go back to the other,
sorry about that.
right there. So what you see on your screen right now is something that SERB cited to in its decision, which actually it had been cited to in a previous decision in which the board was reiterating. As SERB sees it, the statutory commitment to superseding MADs reflects the legislative conclusion that parties may do better or may feel they do better for themselves than government can do for them. Thus, a broad interpretation of RC 4117.14 is warranted in this and similar cases. Of course, any party which feels insecure in the face of a particular MAD proposal need not agree to it. But when agreement is reached, the MAD will be sustained, absent some compelling public policy against it. SERB's general policy in these instances are that it will intervene as little as possible in the contractual provisions of a MAD. It'll only intervene where a MAD is faulty or inoperative, such as a highly ambiguous MAD or where the MAD provisions render it virtually inexhaustible. In this case, the next slide. In this case, what you're looking at right now is the actual MAD that was contained in the parties' agreement. And I'll let you read that for yourself, but essentially, looking at this language, SERB said that it previously determined that a mediation-only process can constitute a valid MAD as long as it's capable of exhaustion. Now, with the language here, SERB found that the parties' MAD clearly sets forth that following impasse, the parties are to engage in a mediation with an FMCS mediator. The MAD further provides that the mediation process concludes at the expiration of the agreement, barring the mutual agreement of the parties to continue mediating. Thus, there was an exhaustion requirement, and in fact, the exhaustion requirement had been met in this instance. Additionally, looking at the evidence of the parties, SERB noted that a similar provision to this exact MAD had existed in these parties' agreements since at least 1985, and that the parties had in fact treated it as a MAD by declaring it as such in several various notices to negotiate over the years, as well as during the pendency of 4 previous strikes. So the SERB board determined that this was in fact a valid MAD, that the MAD did exhaust in mediation, and there was nothing within the MAD that put it back into the statutory provisions of 4117. Thus, fact-finding was not a requirement. So I think the moral of the story here is, if you are going to put a MAD into your agreement, make sure that it's something you can live with, because barring something exceptional, SERB will enforce the parties' agreements. Just a side note, in this case, the parties here did finally enter into a successor agreement, and when they did that, they put the fact-finding back into their process for future negotiations.
Thanks, Robert. And now we're going to move on. Excuse me. We're going to move on to some common ULP issues that are of note to practitioners out there. The first pertains to maintaining the status quo during the SERB representation proceedings. And this is one that I know comes up a lot on both ends, where, you know, maybe folks on the labor organization side might think the employer's paying too much or doing too many things, or trying to change the status quo. And on the employer's end, there is always the concern of how do we maintain the status quo. And as a lot of you know, this comes up fairly often and is sometimes hard to determine. So the case that's always a good example in this is Clark County Board of Developmental Disabilities, which was a SERB opinion from 2010. And again, there's a link at the bottom of the presentation if you'd like to review more. But essentially what happened here is a union filed to represent certain social workers in Clark County. When this was filed, and the parties began the normal representation process, this was filed in May of that year. So the election process was ongoing, and it was ultimately directed to election. The important background here is that for at least the past 10 years, if not more, all employees would receive their annual raise in June or July of that year. However, this year, the employer granted the raise to everyone but the employees that were currently involved in the election, and took the extra step of sending them a letter which spelled out and specifically stated that they were not receiving this increase because the filing had been made with SERB to represent them, and again confirmed that it was a direct result of the election. So again, everyone else except these folks were provided their annual raise as had happened in the past. And so in this case, SERB ultimately determined that this was in fact an unfair labor practice. And among other things, you can read everything that was required by the board, a posting, everything like that. But the important thing here is that that the union had lost the election during while this was being investigated, and during the actual ULP hearing, a couple bargaining unit members or prospective bargaining unit members testified that they had voted no against the union directly because they wanted to receive their raise, and the employer's actions made them feel like the only way they would get their raise, or at least get it in a timely manner, would be to vote against the union. So ultimately, the board ordered a new election take place, and this time the union actually prevailed. So it's a good lesson of, in extreme circumstances, why employers' action, well, either side's actions, but in this case, the employers had extreme consequences for their side, as again, no representative prevailed in the first election. However, after the ULP was remedied and the employees revoted, ultimately the union prevailed there. So again, it's an important example of why this is important, that attorneys and representatives and everyone else just make sure they are maintaining that status quo. But the important takeaway being, if something's been a past practice for a long enough amount of time, it should still move forward as necessary. If it's something that, because again, at the end of the day, the status quo is meant to maintain the status quo at the time it was filed. And so if you already are planning to take an action and can show what happened, it's less likely that a ULP will be found. But if that's not the case and it looks like just a direct retaliation is being taken or an attempt to influence the election, then it may be more likely to constitute a ULP.
Okay, so the two cases you're looking at here are the first two cases where the SERB board had the opportunity to make a decision regarding an employer installing cameras in the workplace. The first, the city of Sharonville, involved a Sharonville Fire Department. So in May of 2020, a letter was sent to all the employees of the Sharonville Fire Department, including bargaining unit members of IAFF Local 4498. The letter was from the city's Human Resources Director, and it informed the employees that the city was going to be installing video audio surveillance cameras in the fire stations. The city informed the employees that these cameras were going to be installed in several areas, including the day room, the kitchen, the lieutenant's office, the break room, the gear room, the report room, the training room, the inspector's office, the mezzanine, the reception area, and the main entrance. All the cameras that were being installed in offices were only being placed in offices that were utilized by bargaining unit members. Subsequently, the union asked to bargain over the cameras and also submitted a proposal to the city, as they happened to also be engaged in negotiations for their successor collective bargaining agreement. However, the city refused to bargain over the matter, claiming that it was a management right. The union filed a unfair labor practice charge over the employer's refusal to bargain. So looking at this issue, SERB first had to determine whether the matters with the installation and use of cameras implicated management rights and or materially affected wages, hours, or terms and conditions of employment. Now, SERB turned to Section 4117.08C of the Ohio Revised Code, and that sets forth the various management rights that the 4117 gives to managers. Now, it includes things such as being able to direct and supervise employees, maintain and improve the efficiency and effectiveness of governmental operations, determine overall methods, process, and means by which government operations are to be conducted, and a whole slew of different rights reserved to management. SERB compared that to Section 4117.08A of the Revised Code. That section requires that public employers bargain with an exclusive representative on all matters relating to wages, hours, or terms and other conditions of employment. So if a given subject involved the exercise of inherent managerial discretion and also materially affects any of these factors, then a balancing test is used by SERB to determine whether it's a mandatory or a permissive subject of bargaining. What you're looking at here is the Youngstown balancing test. At the bottom, you'll see the case that actually arose from. So this is a test that has been utilized by SERB since 1995 in a variety of different cases where both management rights and the employees' rights to bargain over terms and conditions are implicated. So those management decisions, which are found on balance to be mandatory subjects, must be bargained before implementation upon notice by the employer and a timely request by the employee organization. So under the Youngstown test that you see here, the very first criteria is the extent to which the subject is logically and reasonably related to wages, hours, terms, and conditions of employment. So looking at the evidence in this case, the use of such cameras in the workplace directly affected employees' terms and conditions of employment. Not only could the data that they collected be used in discipline of employees, but they could also be used to reveal concerted protected activities protected under Chapter 4117. The board noted that it was important to note here that the cameras installed by the city were also had audio on them, and there was evidence that it wasn't unreasonable to believe that cameras in various locations might also pick up audio from adjacent rooms, making it all the more likely that the cameras would record protected activity communications of bargaining unit members. SERB noted, and I quote, "The video audio surveillance cameras in this case were so pervasive that they were likely to capture everything that happened within the fire stations." So the first part of this test militated towards the union. So looking at the second condition here, the extent to which the employer's obligation to negotiate may significantly abridge its freedom to exercise those managerial prerogatives set forth and anticipated by Revised Code 411708C, including an examination of the type of employer involved and whether inherent discretion on the subject matter at issue was necessary to achieve the employer's essential mission and its obligations to the general public. So looking at the second condition, it was noted that the employer involved in the incident case is a city fire department. SERB noted that the core mission of a fire department is to provide fire protection and emergency services to the population it serves. So a recording of fire personnel during an emergency operation, or maybe even the lobby of a fire station where they interact with the public, may well be considered essential to its mission and obligations to the general public, such that the implementation of those cameras would not be a mandatory subject of negotiation, although the effects of their use might still be a negotiable subject. SERB said that the same could not be said for surveilling the employees in their break rooms and offices. The city stated that it installed the cameras to ensure the safety and security of employees in the public buildings, but there had been no evidence during the hearing that the fire stations had been subject to unauthorized individuals entering restricted areas or other issues necessitating the installation of cameras. Accordingly, the board found that the evidence does not show that the installation of the video audio surveillance cameras was necessary to achieve the city fire department's essential mission and its obligations to the general public in those private areas. Condition number 3, the extent to which the mediatory influence of collective bargaining and, when necessary, any impasse resolution mechanisms available to the parties are the appropriate means of resolving conflicts over the subject matter. So in this case, as I mentioned, the city and the union were actually engaged in negotiations for their successor agreement during the time that the city said that it was going to be installing these cameras. The union asked to bargain over the issue and, in fact, had provided a proposal. However, the city refused to bargain and provided no counterproposal, claiming that it was simply a management right. The board found that had the parties negotiated the issue, it may have been agreed upon and, if necessary, gone to the appropriate impasse procedure where it would have been resolved. In this case, involving a fire department, firemen personnel, it would have ended in conciliation. So applying the Youngstown balancing test, SERB determined that the installation and use of the cameras in the non-public areas of the fire station was a mandatory subject of negotiation, but that where in the public areas consisting of the entrance and the lobby, only effects bargaining was required, because again, those were areas where the fire department may be providing direct services in furtherance of its mission. SERB ordered that the cameras be disengaged until such time as the parties completed their negotiations. Okay, so the second case here was the City of Cleveland case, and that actually came the very next year. Now, whereas Sheridanville was heard before an administrative law judge, the City of Cleveland case was heard before the full board. So, in the City of Cleveland, the EMS commissioner notified the union president in August of 2021 that it had decided to initiate a pilot program of placing dash cameras in EMS vehicles, essentially ambulances. So the commissioner explained in her communication to the employees that the trial project will consist of 3 dash cameras being placed in 2 EMS frontline ambulances. A camera would be installed facing forward from the cab of the vehicle and a camera would be installed facing into the cab that also included audio. The video and audio settings were set to start only during certain criteria. They would only trigger to start recording if lights and sirens were activated, if crash sensors were activated, or when the ambulance was backing up. So one day after the commissioner notified the union of this, the union responded, setting forth, among other things, that they had concerns with the installation of the dash cameras and indicated that they opposed the city's installation and use of such cameras. The union followed up on its concerns and sent another communication to the commissioner requesting that the city bargain the decision and effects of installing and using the cameras in these EMS vehicles. The city's attorney responded to the union's letter, stating that the city had no obligation to bargain the installation and use of these dash cameras due to the enumerated rights and waiver language contained in the parties' collective bargaining agreement. The city also expressed a willingness to meet and confer with the union and review any concerns or suggestions they had regarding the pilot program, although they would not negotiate. So looking at this case, the board determined that this same Youngstown balancing test was appropriate, as this implicated both management rights as well as terms and conditions of employment. So looking to the first prong of the Youngstown test, the board said that there was evidence that showed that the city's paramedics and EMTs assigned to these ambulances spent the vast majority of their shift in these ambulances responding to calls. Given the time spent by the employees in the medic units, this raised the issue of the cameras being used for disciplinary decisions. Additionally, there was a possibility that protected conversations could be recorded by the cameras. So this factor weighed in favor of the union in terms of making it a mandatory subject. However, as to the second prong of the test, the board noted that the city provided evidence that the cameras and audio recording would only be triggered when certain criteria were met. As I mentioned, the lights and sirens activated, crash sensors backing up. Therefore, the recording was limited to times when primarily the paramedics and EMTs would probably be engaged in emergency operations. This was further bolstered by evidence from the union that showed that during the 1 month that these recording devices were actually operational, that only around 30 total hours of video and footage were recorded. So the board said that this was not a situation like in Sharonville, where an employer was engaged in constant and pervasive surveillance of its employees. It was indisputable that responding to emergency calls is necessary to the mission of the city's EMS division, as the camera and audio recording devices are only activated during the stated triggering conditions. The cameras would be recording when the paramedics and EMTs were likely directly engaged in the division's essential mission. Thus, these recordings could be used by the division to directly improve the efficiency, safety, and effectiveness of the EMS division's emergency services mission. So this militated towards the city's position and towards the position of it being a discretionary or a permissive subject. Finally, looking at the third prong, the board determined that the city's management rights were so entwined with its essential mission under the facts of this particular case that it would not be appropriate to require bargaining over the installation of the cameras. Thus, the installation was a permissive subject. However, as the board said, that did not mean that there was nothing for the parties to address at the bargaining table, because the terms and conditions of employment were materially affected, and the union had a right to engage in effects bargaining over those issues. Accordingly, the board ordered that the parties commence effects bargaining process by meeting to define and agree upon appropriate effects bargaining proposals and subjects. Examples of this included, but were not limited to, employee privacy concerns stemming from the recording of video and audio, notice and procedure in the event data may or will be used in conjunction with employee evaluations or discipline, and similar matters consistent with the board's finding. Now, as to the city's argument that the union had waived its right to negotiate this subject in the collective bargaining agreement. SERB noted longstanding precedent that says a waiver must be clear and unmistakable from the terms of an agreement, and where an alleged waiver is based upon negotiations, the evidence must be clear that the union consciously yielded its statutory rights. The board found that there was no such clear and unmistakable waiver within the language of the parties' collective bargaining agreement, and thus ordered the parties to negotiate the effects. Now, just a note on this case, this case was appealed by the city. SERB prevailed at the trial court, and currently it's scheduled for an oral argument before the 8th District on May 2nd.
Thanks, Robert. One more common ULP issue we'll touch on quickly is always that line of when protected concerted activity and or acting as a union representative crosses over into disciplinary action, or whether it's protected by the statute. As always with any legal answer, as you all know, it depends, but this Dayton case is a good example of when folks acting, in their protected concerted activities can still be disciplined, but up to what point, whether it's reasonable or not. So in this one, for quick background, a popular police officer within the department was indicted and suspended without pay, and they were going through the disciplinary process for this individual. After a disciplinary hearing with the police chief and the union higher-ups, they went back to the police chief's office to discuss. He indicated that they were going to uphold the discharge this individual. After a brief discussion, a couple of the union leaders got heated, and one individual said this is BS, and then without shortening it, and another called the chief a bad name and used some other choice language with him that went above and beyond the saying it was BS. So the next day, the chief transferred the individual that had made the more inappropriate comments from his position as a night street supervisor to a counter position working day shifts. And this is important because it was known to the chief and everyone else there that this individual really preferred the shift he had, and this would be seen as a substantial disciplinary action against him. Police department went through its normal disciplinary process and also issued him a written reprimand. The other union leader who just used profanity once was not disciplined. Ultimately, the board held that the employer's issuance of the written reprimand did not violate A1 of the statute or A3, and the involuntary transfer did not violate A3. However, the board found that the involuntary transfer did violate A1 of the statute because it had gone beyond the bounds of a reasonable discipline, and one could reasonably conclude that the employees were restrained or coerced their rights under the statute were interfered with by this action. I mean, again, so essentially it's saying, yes, you can discipline someone for, if they act inappropriately in their capacity as a union rep or are engaged in protected concerted activity. It's not just a 100% cover for any action someone might take. However, that still needs to be a reasonable discipline. And in this case, since it was widely known that the shift transfer would be a substantial penalty to this individual, it was held that while the written reprimand was reasonable, the transfer was too much. And again, that's a good case if you're wondering about that line. And then moving on quickly, we'll briefly touch on some hot topics in labor law, and you're welcome to reach out to us after if you have any specific questions or want to discuss any of these further, since we don't have a lot of time to finish up. But the first is a recent Supreme Court decision in March, Linkey v. Freed. And again, you can find the link there. And the question this asks is whether or not public officials can block social media users from their accounts. And I know this is something that comes up a lot, and as both of these individuals in this suit, and a lot of you out there, I'm sure, we're engaged in posting, everything about their lives on social media, and I'm sure a lot of you also may be similar, but where that question comes up is where it crosses the line into becoming considered state action under the law and when it's not. So for some background, you can read through the cases. It is kind of funny to see the detail is this individual's progression of usage from Facebook from college to professionally to now when he was appointed city manager. So again, it's kind of interesting to, similar folks to consider how your usage may have changed since then if you do still use Facebook. So Mr. Freed, the defendant, was the city manager of Port Huron, Michigan. And an individual named Mr. Linke. So I guess for some background first on Mr. Freed's profile as the court goes through, he was an avid Facebook user, and when he neared, I guess there's a 5,000 friend threshold where you can make your page public once you hit that limit. And so he chose to do so and identified himself as a public figure. And then in 2014, he was appointed city manager of, like I said, Port Huron, and he did update his Facebook page to reflect the new job. He did not have, and it's important the court will note later, that he did not have a disclaimer like you'll see where folks say, hey, this is my personal opinion, this isn't the opinion of my employer, or vice versa. It did not say this is an official account of the city. And in the about section, he did mention that he was a city manager, but mentioned his daughter, his wife, and all other personal information. So as prior to his appointment to this position, Mr. Freed posted, as the court says, prolifically and primarily about his personal life, and focused on pictures of him and his daughter, Bible verses, home improvement projects, pictures of his dog. So again, using it mostly in his private capacity. However, he also posted information related to his job. Some of his mundane activities, about attending events, other things like that. People and some citizens did comment, and he would respond. One example they give is folks saying, can you allow city residents to have chickens? And he responds to this and directs them to the appropriate part of the city government to talk to about that. So then so COVID begins, and Mr. Freed's still posting some personal, some about some public. Enter Mr. Linke. Mr. Linke commented on a couple of Mr. Freed's posts, one saying that the city's pandemic response was abysmal and the city deserves better, and then another where the mayor and Mr. Freed were had posted a picture of them getting takeout from a local restaurant, and Mr. Linke complained that they were out doing that while everyone else was stuck inside. So at this point, Mr. Freed blocked Mr. Linke's comments, and then he ultimately blocked him as a whole. And so as a public Facebook page, Mr. Linke could still access the post, but he could no longer comment. So Mr. Linke sued Mr. Freed under 1983 action, claiming that this was state action. The district court granted summary judgment to Mr. Freed, holding that Mr. Freed was not acting in his official capacity when he made these posts, and then when he took the act of blocking the plaintiff. The Sixth Circuit affirmed, and again said it was not clear that he was acting in his official capacity. Notably, the Sixth Circuit's decision was at odds with Second and Ninth Circuit decisions, which focused less on the actual action taken and whether or not it was an official capacity, and more on the appearance of the page. Does it say, you mentioned the job, do you post about the job? Is your picture in a city uniform? Things like that. So ultimately, the Supreme Court did take this up for consideration, and the court ultimately did side with Mr. Freed, the city manager, and it did an overall analysis of this, but ultimately held that he was not conducting official business that he had the capacity to actually carry out under the city charter or the state law, and therefore his blockings it wasn't clear that it was official action. The court had the two-part test moving forward. states when a government official posts about job-related topics on social media, such speech is attributable to the state only if the official, one, possessed actual authority to speak on the state's behalf, and then two, the purported exercise of that authority, and two, with the post that he purported to exercise that authority when he spoke on social media. And so you can go, we're short on time, I won't go through all the court's consideration, but it went through and essentially said it would be a lot easier if he had either put the disclaimer of it being his private or it being public, but since he didn't, it was considered mixed use. And so then they went through the actual post and determined that he wasn't acting in his official capacity here. And so the main important takeaway is recommend to the clients, if it is, whatever they want to do, that they are clear, whether it's a personal or an official account. And the court says this is creates a very heavy assumption of it being one way or the other, but that's not indisputable if their actions go against that, so to say.
Okay. So both of these cases sort of revolve around the same general question, and that's where where a party brings an action in court for the breach of a collective bargaining agreement and/or to compel arbitration in a collective bargaining agreement, whether or not the court has subject matter jurisdiction to hear that, or whether that's the exclusive jurisdiction of SERB and thus has to go to SERB. So in the first case, the Tip City case, that involved Tip City Education Association and a teacher who brought the action, Jennifer Whitman. So in September 2022, the district received complaints from parents regarding Ms. Whitman. The union filed a grievance on her behalf, and the union said that the district had violated the agreement, the collective bargaining agreement, when it received parental complaints about Ms. Whitman, but failed to encourage the complainants to first discuss their complaints with her. Subsequently, Ms. Whitman was issued an unpaid suspension by the district. In October 2022, Ms. Whitman filed another grievance alleging that this unpaid suspension that she received had violated her rights under the collective bargaining agreement, and that it was done without good and just cause, and it failed to apply discipline in a progressive manner. The matter proceeded through the grievance process. It did not resolve, and according to the party's CBA, if consensus is not reached during mediation, the grievant may seek resolution through legal options. So in March 2023, the union and Ms. Whitman filed their complaint in a trial court, alleging a breach of the agreement. The district filed a motion to dismiss the complaint, and it argued that the union and Whitman's claims arose from the rights enumerated under 4117, and therefore SERB had exclusive jurisdiction. The trial court subsequently granted the district's motion to dismiss, finding that SERB did have exclusive jurisdiction over the dispute. So Ms. Whitman and the union appealed. So in the second department's decision from this case, it looked at revised code 4117.09B1, which states that a written collective bargaining agreement shall contain a provision that provides for a grievance procedure which may culminate with final and binding arbitration of unresolved grievances and disputed interpretations of agreements, and which is valid and enforceable under the terms entered into in accordance with 4117. Furthermore, a party to the agreement may bring suits for violation of agreements or the enforcement of award by an arbitrator in the court of common pleas of any county wherein a party resides or transacts business. Thus, the second department said that this expressly allows for suits alleging violations of collective bargaining agreements to be brought in common pleas courts. It noted that exclusive jurisdiction to resolve unfair labor practices are vested in SERB in two general areas, where one of the parties filed charges with SERB alleging a ULP, and where a complaint brought before the common pleas court alleges conduct that constitutes an unfair labor practice that's as enumerated under 4117. So the second district agreed with the union and Ms. Whitman that the trial court had subject matter jurisdiction and that it improperly dismissed the case. The board, the second district did dismiss Ms. Whitman as a party to the lawsuit, however, because as you can see here under this provision, it says that parties to an agreement may bring suits for violation. As Ms. Whitman was not a direct party to the collective bargaining agreement between the union and the district, she did not have standing to bring this action. So just a few weeks later from that decision, the 8th district came out with the Lakewood case. So Lakewood involved a city and union who were parties to an agreement that contained a grievance and an arbitration procedure. The agreement also said that all decisions of arbitrators and all pre-arbitration grievance settlements reached by the union and the city shall be final, conclusive, and binding on the city, the union, and the employees. So on November 4th, 2020, the city terminated Michael Satink for what it deemed to be insubordinate, disruptive actions in the workplace. The union submitted a grievance. However, that grievance process did not resolve the dispute, and the union tried to move to arbitration. Now, prior to the arbitration, the city asserted that it was not arbitrable because there had been a previous issue regarding Mr. Satink where he had entered into a last chance agreement. And that agreement said that if during the terms of the agreement he violated city work rules, policy, etc., that he shall be subject to immediate termination without recourse to the grievance or arbitration provisions of the agreement. So after the city's refusal to arbitrate, the union filed the union filed with the court seeking to compel arbitration. The trial court sided with the employee and the union and ordered that arbitration be compelled. The school district then appealed to the 8th district. And looking at this, the 8th district said that the rights that the union and the employer were seeking to enforce did arise from Chapter 4117. It says that the claim was premised on the union's allegations that there is an agreement that the city has failed to comply with. That is, if, as the union alleges, the city ignored the CBA by refusing to arbitrate the grievance, then the city interfered with Satink's statutory collective bargaining rights and refused to bargain collectively. The court said that this claim is entirely dependent on and falls within the scope of the rights under 4117. So it dismissed the union and the employees' motion to compel. Now, there was a dissenting opinion in this by Judge Lisa Forbes, and her dissent, if you read it, goes very much along the same lines as what we just discussed in the Tip City case, stating that 4117 permits parties to file in a common pleas court on issues of a violation of a collective bargaining agreement and or to compel arbitration. So this particular case, the Lakewood case, has been accepted for review by the Ohio Supreme Court. So we expect in sometime in the hopefully not too distant future to get some more guidance from the Supreme Court on exactly how this provision 4117.09b operates.
Thanks, Robert. I know we're over our time, but we'll real quick just touch on this. I'm sure you've seen this as analysis of this is everywhere. So if you want to read deeper into the Dartmouth men's basketball unionization through the NLRB process, you can do so. Currently, the regional level, they were it was deemed that the individuals on the men's basketball team were able to bargain, and they did unionize, and they did ultimately vote to unionize. However, the process is still ongoing and has been objected to by the university, so that's something to keep an eye out for. And again, there's a lot of material on that. As far as it relates to Ohio, in 2014, an amendment was added to the state budget bill stating that students attending state universities in Ohio are not public employees based upon participating in athletics for the state university. And so that's currently what's in place. And again, as anyone that, watches college sports or anything else is seeing, this is going to be an ongoing evolution. So again, that's currently what the law is in Ohio, and it'll be interesting to see how that moves forward. So with that, we just want to say thanks for attending today. Sorry we didn't leave any time for questions. If you do have any, you're welcome to reach out to Robert or myself. I believe our email is on the last slide here, and you can always find our information on SERB's website. Thanks so much.
Thank you so much, gentlemen. That was an excellent presentation with a lot of great information for our folks. Some really interesting new cases. So thank you very much for speaking today, and also the data and the great news on the database online. So thank you very much for the updates. We hope everybody enjoyed attending today as much as we did hearing what they were saying. And we are, like I said earlier, going to have 1 hour CLE credits. So for all of you who did enter your information, you should be receiving a certificate within the next day or two, and your information will be uploaded to the Supreme Court's website. I just wanted to also let you know before you sign off that we do have our final event of the year coming up in May. It will be on May 21st, and this is going to be an in-person event for those of you who might not have known yet. It is actually got 2 classes that we will actually have lecturers speaking on. One topic will be strategic decision-making in the public sector by Valerie Lemmy. And we also have John Dean from the Columbus City School Board, Phil Hayes, and John Caniglio, who will be speaking about the Columbus City Schools contract negotiations and strike in 2022. So some great folks that are going to be speaking some really interesting topics. And we are going to be having that at the State Library downtown with a meal served by Bravos. And then we will actually have happy hour afterwards like we have in years past. So we look forward to seeing everybody there. And thank you so much for attending today. Have a great day.